Katie Frekhtman, a New York City personal injury trial attorney, and I'm coming to you today from my Brooklyn office in Bensonhurst. It's a really sunny day, and I'm looking out onto the windows. I'm getting a lot of sun, and it's a beautiful day. So today I wanted to talk about an interesting topic, and that is, does it matter more what you say, or does it matter more how you say it? And in reality, both are very important. What you say is obviously important because a case has to have substance, it has to be meaningful, and ultimately you have to be a truth teller. You have to be able to tell the truth to the jury, and the jury has to believe it. Otherwise, you're going to lose your case. But is it also important how you say it? For example, your body language, if you're shy, if you're hesitant, if you're meek, or if you're strong, if you're standing up, if you're, showing nonverbal cues and you're powerful. And so one of the things I was talking about a few videos ago was a case in another state where lawyers recovered $12 million for a non-surgical herniated disc, and the verdict was $9.7 million. And I watched a CLE, which is a continuing legal education, all about that trial because that's a very interesting case. They got an excellent result, So, two things that I learned from that CLE about this topic, about is it what you say or is it how you say it? First of all, the lawyers that tried the case, they're very big on persuasion, nonverbals, body language, and just an overall, like one of the lawyers, he's a little bit older, he's like 70 years old. He didn't actually try the case. I believe his son tried the case, but he did a trial college this past weekend. And I attended a few sessions via Zoom, and he was giving books to read about persuasion, different ways to be persuasive. And so that a lot of the college was not about the substance, but rather it was about, how you say it and your approach, and also how you deal with objections, like from the other lawyer, from the judge. Sometimes judges could start berating a lawyer, yelling, being angry, and it's how you handle that. Whether you're cool and calm and just kind of, flick it off like it's a little fly, or whether you react to it and then, you get fearful, or you get angry, or you can't function, and then, that could tank your case. So it's very important to be able to be cool. But the two things that I really liked from this CLE that deal with this topic was, number one, in jury selection. So they're picking a jury, and it's a bunch of different lawyers. There was one lawyer representing the plaintiff, and then there was another lawyer who came in from out of state that represented the wife in a loss of consortium claim. So there were two different lawyers, right? And they're both picking a jury, and they're getting a lot of people off for cause, which means that the person's beliefs, their state of mind, their feelings, basically they can't be fair to both sides. They're giving one side a little bit more credence, a little bit more of their beliefs right from the very beginning. Like if it was a race, the defense would start out ahead because of people's beliefs. And so they got 54, I believe, people kicked off for cause. So one potential juror was actually a doctor. And the doctor, I believe he really wanted to be on the jury because he was retired, right? And he thought it was like an interesting case. He's like, yeah, I'm gonna get on this jury. And they didn't want the doctor on the jury because he seemed to be very conservative, very much against plaintiffs. And so they asked him, they said, doctor, do you know that the law is in this state, and the pattern jury instructions say that the evidence has to come from the witness stand. So for example, if a witness, and a lot of the witnesses will be doctors to talk about injuries, including this soft tissue herniated disc. So if the doctor says one thing, and then you go back there and you start deliberating, right? And you start talking to each other, and you're one of the jurors, would you listen to what that doctor said? Or would you tell the jurors your own medical expertise? Since you're a doctor and you've been a doctor, you're retired now, but you've been a doctor for like 30 years, are you going to start talking about your own medical expertise, and maybe that could taint the evidence? And he could not give that assurance that he would do that. So then they took him outside and they had more of a conversation with him one-on-one. It was the plaintiff's attorney and the defense attorney. And it actually ended up that the defense attorney, the attorney representing the insurance company, was the one who wanted this doctor off for cause, for whatever reason. It was a private conversation. So then they go back in there, and other jurors, they see that this doctor is leaving, that he was excused, and one of the other jurors screams out, and he says, well, if they got rid of the one doctor, then you know they're a bunch of frauds. And so the plaintiff's attorney, he was like, oh my God, I can't believe this. He just yelled that. We're done. We're cooked. I'm sorry. He was apologizing to like the out-of-state attorney. He was like, I guess we're cooked. I guess we're done. I'm sorry. But you know what? They kept it together. They stayed confident. And despite that, look at the result. And it just goes to show that it doesn't matter like what one juror says, somebody yells something, that doesn't really influence other people. Each person is going to form their own beliefs. It's more important to have the group formation and form a group and stay confident. So that was one thing that I felt was very interesting. So even in a case like that, where somebody wins a $10 million verdict, they have issues like that, you know? And then the other thing was this lawyer that I talked about, I believe he was from Nebraska, the one who came in to do the loss of consortium claim. So he's giving his opening statement. And, he told the judge before that, I've tried a lot of cases, this and that. And in his opening statement, he starts talking about himself, like his personal life. Since he's representing the marriage, a lot of what he's discussing deals with issues of the marriage, right? Like loss of love, loss of affection, the fact that the wife had to then nurse and care for the husband, who before the accident was more self-sufficient. So he, in many ways, he represents the marriage and how the marriage was affected. So he gave some examples from his personal life, because he's been married for a long time. And as soon as the defense attorney heard that, he said, objection, that's not proper. And then they had a sidebar where you go and you talk to the judge privately, and the judge admonished him. The judge even said, come into my chambers. He took a recess and he started yelling at him, and he said, I can't believe this. You told me you tried cases and you don't know that you can't bring up your personal life. So for many lawyers, something like that, the judge yelling at them like that, making them seem like they don't know what they're doing, that might make them get upset. And then from then on, the case would just tank. But not for these guys. You see, they kept it cool. They kept it calm. They stayed confident in the case. And again, the end result was $10 million. Despite these two things, somebody yelling, these guys are a bunch of frauds. And then, the judge yelling at him in front of the jury, sustaining the objection, and then continuing to yell at him in the chambers. But see, it just goes to show that it happens to the best of lawyers. Nobody is so perfect, right, that they're going to be without objection, and nobody could know what's going to happen in a trial, because by its very nature, a trial is like an inferno, right? You go into the fire, you don't know what's going to happen. So you have to be fearless, you have to be ready to roll with the punches, just like a boxing match. And that's why, the more you learn, the better. The more trials you do, the better you get, and that's the best experience, is doing trials. But I just thought this was an interesting, those were really interesting things for me as an attorney. And so both matter, of course, but how you say it is so crucial. Not just what you say, but how you say it, the nonverbals. And just, I think for me, one of the really important things is truly understanding a client and truly loving that client. And then that shows to the judge, to the defense attorney, to the lawyer. And when they see you walk in there with that confidence, you're unstoppable. Okay, everyone, have a great day. Let us know what questions you have, because we are here for you and we want to help you. Okay, have a great day. Bye-bye.